Thank you for listening in to this brief introduction I'm going to give to my new book, International Commercial and Investor-State Arbitration, Australia and Japan in Regional and Global Contexts. International arbitration has become the preferred mechanism for resolving cross-border business disputes amongst both commercial parties, usually based on a sales contract or other underlying contract, but also more recently between foreign investors and host states, usually based on a standalone bilateral investment treaty or free trade agreement investment chapters and the commitments that host states make in those instruments towards foreign investors to encourage investment. And the main reasons for the attraction of arbitration as a dispute resolution mechanism are the easier enforceability of the arbitration agreements and or the awards that come from the arbitrators, even compared to cross-border litigation, as well as the neutrality of the chosen arbitrators. But another attraction has also been the flexibility of arbitration procedure. And we've seen a good example of that flexibility in the way that many arbitration hearings have pivoted to being conducted virtually during the COVID pandemic from early 2020. However, interestingly, that technology for virtual hearings has been around for a long time, and yet arbitration practitioners have not been so active in taking it up more voluntarily. Because arbitration is based on agreement, and therefore if one party or the arbitrators are not so happy with, say, a new way of doing things, it can't happen. And more generally, one of the perceived problems with arbitration has been resurgent costs and delays, particularly over the last decade. What I call in this book the formalization tension or informalization tension. And this has been exacerbated because, ironically, there are few competitors for arbitration as a dispute resolution mechanism in cross-border contexts, and also perhaps because of the confidentiality that's often introduced, particularly in the commercial arbitration world, for some good reasons, but which has the effect perhaps of exacerbating delays and costs. And another problem with arbitration has been the tension between internationalization, following internationalist interpretations of underlying arbitration instruments that many countries have adopted, versus local interpretations, local practices, and so on. So what I call and others call the glocalization tension. And so this book takes a closer look at both of those tensions, the informalization tension, the glocalization tension, focusing particularly on Australia and Japan, but in regional and indeed global context. I focus on Australia and Japan because both countries have been trying, Australia a bit earlier than Japan, but actively trying to become more popular venues for international arbitration, to engage more with the arbitration world. And in the first part of the book, I concentrate mainly on international commercial arbitration, including, for example, some empirical research into court case disposition times for arbitration matters, which arguably gives us a sense of how formalized the arbitration practice and norms are in different countries. And I also look at the processes of law reform in the different countries, which gives us perhaps also a good sense of the extent to which globalization is having an impact in those countries. The second part of the book looks at crossovers between international commercial arbitration and investor-state arbitration, looking, for example, at the tension between confidentiality versus transparency, how that plays out in different countries, and the effects that might have on the overall shape of international arbitration. The third part of the book concentrates on investor-state arbitration. Includes, for example, quite a detailed description of the complex politics and economics around this field of dispute resolution that's evolved in Australia, where, for example, an Australian government from 2011 until 2013 decided that Australia would no longer agree to investor-state arbitration provisions in future treaties, partly because of, around that time, a first ever claim brought against Australia by Philip Morris Asia under an old, now superseded, bilateral investment treaty with Hong Kong regarding Australia's tobacco plain packaging laws. Interestingly, and this is a footnote to the book that's just been published because it's new to the world, we have Japan in February 2021 reportedly being subjected to its first ever inbound investor-state arbitration claim, reportedly also under Japan's treaty with Hong Kong, and it relates to alleged losses suffered due to Japan changing its renewable energy policy, which is somewhat ironic because the book does talk about the fact that most of the outbound claims by Japanese investors under investment treaties have been by Japanese companies against Spain for its changes to renewable energy policy. And so in the concluding chapter, the book returns to the question posed about the future path of international arbitration, particularly in the post-pandemic world. Will some of the efficiency gains and a new sense of globalization in the arbitration community, will that prevail even beyond the pandemic? Or will we see a reversion, as we've seen in the past, to renewed costs and delays and some parochial attitudes resurfacing? The concluding chapter also urges countries like Australia and Japan, but particularly others perhaps in the same region, to work together at different levels to try to encourage both a global and more informal approach to arbitration so that it remains the genuine preferred method for resolving disputes into the future. So I hope you are encouraged to have a look at the book and enjoy reading it. Thank you.